Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our civil number 14-781, ACLU versus the Arizona Department of Child Safety. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, you need to keep track of that time for yourself. Thank you. We have read the briefs in conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Thank you. Good morning, Your Honor. Keith Beecham, representing the appellant, ACLU of Arizona. I'm aware that the court members have all read the briefs, et cetera, so I'm not going to repeat what's in my brief. I'm going to try and address a couple of issues, and I'm going to save some time for rebuttal. What I'd like to start with, I'm going to skip over the issue of is it a public record. I think we've covered that in our brief, and I think that's fairly straightforward.
Well, I think the question is, what is the it in the it is a public record? Is it the database? I noted that in the amicus brief, and if there's anyone in the courtroom that participated in the amicus brief, I would just like to say that on behalf of the panel thought the amicus brief was very helpful and well written, and we appreciate it. The amicus brief made the point that I think that the parties, that there had been some type of an agreement, not agreement in a formal sense, but an understanding that the database was a public record. I think that's your position, right?
That is our position,
Okay.
Your Honor.
I'll be asking your loyal opposition here whether the department agrees, because I understand Mr. Flanagan's testimony at the trial, which he didn't agree, but it seemed like there was a bit of a shift in position in the briefing on appeal. So we start with the child's database is a public record, but isn't the dispute then over what it is you requested, or excuse me, not you, but your client requested?
That's the dispute that the state would like to have. I don't think there's much to be disputed there. The material that's in the child's database, those electronic records, are public records by any measure. Correct. And I think that the state has conceded that in the testimony below. In a typical case, the state would have to give us that information, and they could either extract it for us or make them available. They can't give us the child's database because it contains confidential information.
Well, no, they could do that. They just have to strip out and redact the confidential information. Now, it might be a bit of a challenge to do that, but there's lots of cases, both in this state and other states, in which confidential information is contained in a computerized database, and along with non-confidential, and you just go in there and you strip it out.
That's exactly what our request would have them do. I don't think they can give us the database because my understanding of the architecture of that database itself is that they can't redact the information within the database and then provide it to us. And in fact, they don't.
Where would be the evidence in the record that, well, I'm not sure that issue is directly before us, but I know that Mr. Flanagan certainly objected to that, and there's some discussion of confidentiality, but I didn't see anything in this particular record in which the department presented evidence that it would be impossible. It would be impossible from a technical standpoint to redact, well, confidential information.
I think you are correct about that, Your Honor. I will say that the testimony of Mr. Espadas, and there's depot testimony that was admitted at trial in addition to his trial testimony, but I believe the depot testimony of Mr. Espadas makes clear that the only manner in which this aggregate data can be used by the department, by us, by the legislature, by anybody, is to extract raw data from the child's database and put it into a different data file, and then use that data file to produce whatever information they want to produce, or we want to produce, or anyone else wants to produce.
Well, that's true. But I don't know if we have to go down that road, because the ACLU did not request the child's database, and it surely didn't request any of the flat files or the data files. So, I mean,
well,
that's just not what it requested.
The ACLU's requests, I'm going to talk about the May 2013 request in particular, but the ACLU's requests, and I'm now quoting from the May 6, 2013 request, which is Exhibit 3, says, please provide any and all records reflecting the following public information, goes on to say for the following years, etc., in accordance with how such information is kept, colon. And then there are the lists of the information my client has requested. So I don't think I would agree with you that we didn't request the child's database. We're requesting the information and the manner in which they store it, and the manner in which they store it is the raw data is in the child's database. Mr. Flanagan and everyone else can't use that data. They have to extract the data and put it in a load file, and from that generate reports. That's how this works. And so we've asked them, the Category 1 requests that are at issue here do not require them to get anything out of the child's database, because the Category 1 requests, by their definition, are already contained in the load files and have been extracted from the child's database. It's only the Category 2 requests, of which there are few, that would actually require them to go into the child's database to provide the information requested by my client. If you have some more questions on the public record issue, I'm happy to answer them
well,
now or later.
I actually have a lot of questions on that, because I don't necessarily agree with your statements that you just made about the evidence at trial, the evidence presented. Certainly by the time this got to trial, what was in dispute were some very specific requests, and some of them fell in Category 1 and some of them fell in Category 2. But when I look at those requests that were in dispute as of the time of trial, it seems to me the real crux of this problem is to respond to those requests that were still in dispute. Did the department have to create a record, a new record? That's one way to look at it. Or was it simply a query? If it's just a query to get information out, that may well not be a new record. But when I read the individual requests for information, they seem to go well beyond a query. It is what the amicus brief talks about as basically an aggregation of information, a quantification of information, or a distillation of information. And what I'm not persuaded here is whether the state public records statutes require the department to distill information, to quantify information. Database is one thing. And I won't debate whether you asked for it or you didn't ask for it. By the time we get to trial, though, we're dealing with those particular requests.
I think the law is clear, and I think the law is rightly decided. The law is clear that the form that the government uses to store its information is the form that it must use when it's responding to public records requests. That's in the appellate decision in Lake, which I think
yes,
you were part of.
Great decision, at least the dissent one.
So
but
the only way to get the data that we've asked for is the same. Literally, the only way to get the data is to do what we have done.
No, you could have asked clearly for the database. You could have then hired and rented your own mainframe. You could then have gathered up all the information and analyzed it yourself.
Well, that's correct, Your Honor, and this request is structured in a way that calls for the database. I just read the language out loud. So you may be looking at the individual requests. Those are prefaced by a paragraph above it that says, we want all the documents that show the following information. And so if they had a file cabinet and they wanted to say, you can go look in the file cabinet for the individual records about which of these children was in a group home in Pima County on this particular date, we could do it.
That may well be what was in that letter. But that's not the issues that was teed up before this Superior Court judge. The case had evolved and shifted. And I don't see anything by the time we get to trial in which you're saying, give us the database, give us the database.
Well,
I look at your proposed findings and fact and conclusions of law, and I don't see anything that says we asked for and we're entitled to and we want the database.
There is a colloquy in the transcript, I don't have the page cited at my fingertips, at the preliminary injunction hearing, at which the judge asked that very question.
Right.
It might have been the OSC, but I think it was the preliminary injunction hearing.
The injunction hearing is after all the evidence.
Yeah, and I think the state says during that colloquy, and the judge sort of leads them there, you can't give them this database because it's got confidential information, putting aside the architecture. If there was a mechanism for them to do that, then we would take it. I don't think there is a mechanism for them to do that, but that's not our fault, and it doesn't protect these documents from the record. Now, what might be more squarely within what you're talking about, Judge Norris, are the load files. So when they've extracted information from the database already and put it into a database that is a manageable database, that's not a report. That's just a better way for them to use the information. It's certainly possible they could give us that information and we could use that information. They never offered to do that, and with all respect, we're not required to ask for it. The requests that we have are broad requests that say, we want all your records in the form in which you keep them. That's what that request says. And if they elect to say, the only way we can give it to you is X, and X is too burdensome, that doesn't shift this, doesn't make it our fault, or it doesn't excuse this from being a public record. I wanted to talk a little bit about burden and about interest and about the countervailing interest.
I'm sorry. We've got your argument on burden. I'm still back on the public record, which I find a really difficult issue. I was trying to think about how best to explain my concern. And maybe it's like this. If I ask for the department to give me all records reflecting children in care in Maricopa County that have the name Pat, okay, they have to make that query. But I'm not asking them to analyze the information. I'll get all those records and I can look at them and pull out information. But instead of asking it that way, I say, give me the percentages or the total numbers of kids in care in Maricopa County that are named Pat for a period of time. Now what you've asked the department to do is to go in and start counting heads. And it strikes me that the first may well be a public record request. But the second is materially different, because I get back to, and I thought the amicus brief discussed this quite nicely, it is you're asking the department to produce a form of analysis or not aggravation, but aggregation, you're not aggravated, I know you're not, aggregation of information, and that's different.
Well, aggregation and analysis are different, Your Honor.
Tell
and
me
what
the
we've
difference.
asked for is aggregation. We're not asking Mr. Espadas or anyone else to exercise their own judgment about anything other than applying the data they have to the requests that we have made.
Okay, if you're asking then for
It is counting heads, and that counting heads is aggregation, not analysis.
So we have that. What in Arizona allows your client to get and put the burden of aggregating information as part of the public record response?
We haven't put the burden on them. They put it on themselves.
How do they do that?
By storing the data in the way in which they've stored it. The information that we are asking for is information almost across.
I guess I get back to my problem with this record. I don't see anything in this record by way of evidence that says if you ask for the information regarding all of the children named Pat in care for a given month, that they can't give you those records. I just don't see that in there.
Well, if that's not in the record, then I think you have to reverse, not affirm, because we've asked for it. And if they want to say we can't give it to you for the reason you just articulated, it's not my client's fault. My client has asked for exactly what you just said, and they can't give it to us because it's confidential and because of the way they have their database stored. But that doesn't mean it's not a public record. It's absolutely a public record for the variety of reasons we go through in our papers.
Their IT director, Nick, testified that they can get, really quite simply, information relating to a particular case and information or records relating to a particular case or a particular child. So he testified to that.
That's right, but that...
If you had said, give us information relating to all these kids, without knowing their names, but all the kids in Maricopa County under care for this time period, I think they could have spewed it out.
Your Honor, with all respect, and I would just invite you to go look at that May 31 request. That is exactly what we asked for. We asked for all documents that show the following information and the manner in which you store them. That is what our request says.
But forgive me, and then we'll move on, because
And
I
they
want to
can't
allow you to make your other points. And then you went into the particular paragraphs or the numbers. And now you want, for example, the ACLU in paragraph 18 says, well, on top of that, we want, and I could pick others, but we want the average number of placements experienced by children in out-of-home care as of the last day of various periods of time, based on their distributions of age and 1 year and so, or amount of time they're spending, 1 year, 1 to 2 years. That, as we've discussed, is an aggregation of information, goes well beyond just giving raw information and records.
Well, I agree, but that doesn't mean it's not a public record. The government agency can either give us the raw data and let us count our own paths up, or it can do the counting for us, and it frequently, typically, that's what agencies do when they can do it, and they can do it here. I think the best answer to your question is Exhibit 44 is the spreadsheet made by Mr. Espada. And Mr. Espada in these categories has a category that says we do not have. And you won't find that category on here. Mr. Espada in this and in his testimony says we have all this information. So they
can figure
and
it out.
either he can aggregate it or he can give it to us to aggregate. They can't give it to us to aggregate because of the way they keep their database. But if what you're saying is, well, therefore none of this information is a public record, that would seriously undercut the public record statute, and it would undercut the DCS statute as well, frankly. Let me talk. I do want to talk a little bit about the public interest at stake here, and maybe this ties in a little bit to what you're talking about. I wanted to give you some sense, because I think if the court concludes there's some burden, assuming you conclude there's a public record here, and you assume as a matter of law that burden matters and you can get past the evidentiary problems they have with burden, then you weigh it against what's the countervailing public interest. And the countervailing public interest here is substantial. The information my client has requested is information that is not available elsewhere. And an example that's not the one I picked, but the one the judge picked and the one the state picked is request number 12 of the May 6, 2013 request. That request asks for all records in a 3-year time period in accordance with how the information is kept, reflecting the number of children who were substantiated victims of child abuse or neglect perpetrated by their caregivers while placed in each of the following out-of-home care settings. A is unlicensed foster care, B is licensed foster care, C is congregate care. The department wouldn't give us this. The request in number 12 is important because the department's reports don't break down by the 3 categories that I described for you the information that's sought. They have it, but the reports they generate don't break it down. My client's concerned that Arizona is not including child maltreatment by unlicensed relatives in the reports that it provides, and that's 40% of the foster care people. So there's a substantial concern that the reports the state's generating are inaccurate because of the way they're slicing the data. They can slice the data to answer this question, and they don't have to do any analysis. They just have to take the fields that are in their database and load it into the report, which is what they would do if they thought to answer this question. And that's very important. I cited that Chapin Hall audit report in our reply brief. The Chapin Hall report makes clear that the reports being generated by the department do not cover staff compliance with law. The reporting's been unchanged over many years, and that the format of the reports, and I'm quoting now, the state relies almost exclusively on cross-sectional data as opposed to data that captures how children move through different parts of the system over time. Snapshots of activity tend to distort what is happening. That's not my client saying that. That's the experts hired by the department saying that in their public report. And what my client's trying to do is to get information about how children progress through the system, like examples of number 12, instead of here's how many people were in congregate care on a particular date without reference to how long a particular child was in congregate care. Those are the things we need to know to protect our children. Those are public records. They're in the child's database, and they ought to be produced. I'm going to save what time I have left for my rebuttal unless you have any more questions for me now.
Thank you, counsel.
May it please the Court, my name is Dawn Williams, and I represent the Department of Child Safety. Arizona's public records law was designed to shed light on government operations, not to overtake them, but that's what ACLU is asking you to permit them to do. As we've discussed, the types of requests that they've made are particularly onerous. They would require a single employee full-time to devote 5 months to prepare and generate the information that they've requested.
But it's still a public record.
There are public records, but they have the specific information that they've requested is not a public record, or it's not a record that currently exists.
Couldn't you, is it possible just to delete the confidential information and provide the information?
Well, there are two different pieces.
And then they
here.
can manipulate them or leaf through them as they want?
The department attempted to do that in response to some of their requests, to say, here are several reports that we have prepared that we think you can cull the information that you want out of. And ACLU indicated that that was an unsatisfactory response.
Well, but they want the underlying data, and aren't they entitled to do that as a public records request?
Well, there are two different pieces here. For the department to be able to provide the entire child's database, that's when we get into the best interest of the state, because in order for the department to be able to provide that database so that they can search it and aggregate their own data that they're looking for, the amount of time and effort it would take to extract all of the confidential data would be insurmountable.
But there's no evidence in this record that I saw that quantifies how difficult it would be to extract confidential information. I know it is discussed, and Mr. Flanagan asserted it, but there was, other than just some general assertions, there's no evidence in this record about that. Let me get to the question. You heard the discussion I had with Mr. Beecham about this, and it may well be that I just fundamentally misunderstood this. I did not understand that the ACLU had requested basically a duplicate of the database. I certainly did not understand that that was an issue in dispute at trial. What is the department's position as to what it, let me just ask you straight up, do you think the ACLU requested the database?
That was not our understanding during the course of the litigation either.
Is there somewhere in the record I can go and look to see how the parties actually treated what the ACLU had requested by the time they went to trial that could clarify this?
There were some email exchanges that were included as exhibits, but I don't know how comprehensive they were. Once the lawsuit was filed, the counsel for the department and counsel for ACLU met to try to arrange some sort of compromise to provide some sort of responsive data without having to do all the work of analyzing all the data as they had requested. And ACLU refused to compromise in any way, said, give us the data as we've requested it, or you're not producing and we'll continue with the lawsuit. And so it was our understanding throughout that they were requiring that data as they had requested it. And
the aggregate information.
The aggregate and the analyzed, as you pointed out. For example, one of their cases required the department to come up with the number and percentage of children who were in custody for 15 of the last 22 months at the end of various fiscal years, and of those children, which ones hadn't had petitions to terminate parental rights filed. So that was going to involve looking through various points in the database to even try to get a responsive set of data to query. And so doing that kind of analytical research for a public records request isn't required under any of the public records laws. And so had they requested a full set of the child's database, had they said, we want all of the information in child so that we can get all the information we need out of it, then at that point we would have presented the evidence about what type of burden it would be to be able to produce that kind of record. But throughout our negotiations prior to and even during the lawsuit, our understanding was they wanted the information in the format they had requested it, or they didn't want it at all.
Let me raise a question regarding the findings of fact and conclusions of law. Let's assume for the moment that we basically agree with the department's position. And that basically agree is on the point the department is not obligated under Arizona law to provide aggregated information, which I am going to define for just discussion as analysis of percentages or numbers other than just raw data. Okay. The judge's findings, and I recognize they were submitted by the department, have some incredibly broad statements that go beyond that. For example, I was just looking at if the agency must comply raw data, this is a page 11, the very lines 1 and 2, so it actually was paragraph 7 in the conclusions. If the agency must comply raw data and perform a statistical analysis or write a new software program to obtain the information, it is the creation of a record, not a public record, is not required. Now, insofar as we've just had this conversation about, well, they don't have to do analysis, okay, that might be a correct statement. But when it says write a new software program to obtain the information, for example, if I go to Westlaw and I put in the search box a statutory site within so many words of another site, I have created a search. I have created essentially a software program. If I ask the department, give me all of the records regarding kid's name Pat in Maricopa County, that is going to require a search, a software program. It may be very basic, but it is in fact a form of program. That portion of that sentence may not be correct. So if we generally agree with the department, what do we do with this order? Do we vacate it and have you all go back to Superior Court for more tailored findings and conclusions, or how do we handle this?
Well, first of all, I would dispute your analogy.
Okay.
I think the fact that you could use a search algorithm already contained within Westlaw to locate the information
It's a bad
you need.
example, but I'm trying to keep
Sure.
this in terms that we can all understand.
But
okay?
I guess
Yeah.
to extend the analogy, what they are requesting is that you call Westlaw and say, I would like to do a search that isn't included in your software, and I would like you to prepare it for me. And in addition, I would like to not be charged as part of my subscription
Well,
for
but
that.
I look at
And-
this, just the literal language of the judge's order. For example, under the old days when we did everything by paper, I might go into an agent and say, here's my letter requesting information. And the person at the front desk might say, thank you. And then they would take that letter and perhaps they would attach it to a memo that they would write to their colleagues. So now they have created a record that maybe summarizes what I asked for. We now move to the computer world. Mr.
Espadas?
Espadas?
Espadas.
Thank you. Mr. Espadas explained that you can get from the database records based on individual children by name or by case number. But that also requires a bit of massaging. And my point here is that those words, those 4 or 5 words, are not linked to any refinement. And if we do agree with the department, what do we do with some of the statements in that order that do seem by themselves to be overbroad? Do we get rid of the whole order? Maybe Mr. Beecham would like that. Or what do we do? What do we do with this thing?
Well, I would, first of all, the department would disagree that the order was overbroad, but even if the court assumes that that particular phrase does encompass more than the court is willing to support, that doesn't negate the entire decision. For example, the court also made all of the findings regarding the best interest of the state analysis. So under either analysis, the department was not required to produce the records as requested by ACLU. In addition, if the court thinks that additional evidence regarding what would happen if they had, in fact, requested the entire database, that's something that we could go back to court and litigate if the court thinks that is necessary. I would ask the court, if you do feel that there are some uncertainties in that matter, that you not grant their request for attorney's fees, since it's clear that there are some issues that need to be addressed in this, and so their request for attorney's fees, we argue, is inappropriate because they did not substantially prevail. But also, clearly, the court has questions, and they are challenging the decision of the lower court, which also had to make some parsing decisions on this matter. But I think the court can resolve this without sending the whole matter back to the trial court. There is case law, too. I would point out to the court the recent Division II case from January, Hodai, where the court said that the plaintiff wasn't required, or the state agency wasn't required to provide a data dump, the entire data file, if there was sensitive information in that. And that's exactly what we're getting at when we look at the child's database. I don't think anyone has disputed the fact that there's a whole lot of information that's confidential that ACLU would not be entitled to in that database.
But I thought the question that this case raises is, you have information that's public, and the question is, what can you be required to do to access it to make it available to the public? I'm having trouble. I mean, I'm good at dumbing down Judge Norris's questions because dumbing down is completely in my wheelhouse. But if you have the public records in a locked file cabinet and you lost the key, and somebody wants the documents, the citizen wants the documents, and couldn't you be required to formulate a new key to get into it? And so if you have it within your capacity to write a program that will retrieve the public records, isn't that consistent with what the law really wants us to accomplish here as far as public records?
But that's not what they're asking. They're not asking us to just get a key. They're asking for us to get a key and then take out all the paperwork that's in that file cabinet and rearrange it to their liking. And that's not something that the state is required to do.
And a formula, a program won't do that?
Well, it's a little more complicated than that because the department first has to identify all of the various data points that they're requesting, then write a program, and then they have to test it. The reality is that
More complex, but is it different in kind or quality from formulating a key that you don't have?
it is, because formulating a key is fairly straightforward. You already have one key, you're just making a copy. Whereas in this case, you're creating an entirely new lock. And so the type of key that you're creating doesn't match up to anything else that currently is in existence. So they're asking the department to basically change the locks on all of its file cabinets to suit their key.
In looking at the order here and looking at it really carefully, I saw that the judge identified as an issue the child's database. I believe this was in the conclusions of law at page 10, paragraph 4, when the judge said, what is at issue in this litigation is what non-confidential data in child's is a public record, and then it went on to identify other issues. But I did not see that issue answered. I did not see a conclusion that the court drew, which, for example, such as, yes, non-confidential data in child is a public record. I see the issue was teed up, at least in this, but I don't see an exact or an explicit finding. Do you read the order differently?
I think the literal wording of the order, you're correct. I think if the order taken as a whole does resolve the fact that while the data inside child's may be a public record, aggregating and analyzing that data may not be.
I think your point is, I think you're clear. I agree with you that the order clearly does that. Okay.
Let's see. I would also point out that the ACLU argues that they have a public interest in this information because the data isn't available elsewhere. The issue isn't that the information isn't available elsewhere, it's the method by which they've requested that it be obtained. The department provides a great deal of information regularly to a variety of parties, the legislature, the governor, internal reports to the federal government, and all of those reports are available as public records, and the department attempted to provide those records and those reports to the ACLU. The problem is that they're not requesting reports, they're requesting information. And what they have done is served basically a set of interrogatories to the department. And the department is not required to respond to interrogatories under the public records law. In fact, the information that they did receive was then turned over for a lawsuit, which is generating similar interrogatories. So the fact that they are requesting this information is really in some ways an end run around the public records law rather than actually a public records request.
How would you suggest that they should have restructured their request initially?
I think had they made it clear that they were looking for the entire database, the department could have responded to that. Given that, I don't think the department would be capable of providing the entire database. Had they been willing
So
to...
if they wanted to look at the the database for fiscal years 11, 12, and 13, for example. Then you could have, the two parties could have talked about that, and to the extent they could have gotten that information for whether it's Maricopa, Pima, or the state, and then they could leaf through it to determine, hire an intern or extern to determine, child's age, the nature of out-of-home care, when the dependency or termination occurred, when placement occurred, some of the things that may well be in the other reports, but not with the detail that they're seeking.
And I think had they, when the parties met and the department attempted to say, all right, you've made these requests, you've made several additional requests, how can we, if we can't meet all of these requests, how can we structure what we can meet? And their response was simply, we thought we were having this meeting so you would tell us when you would produce everything we asked for. Had that meeting gone differently, perhaps the department would have been able to say, all right, here's the universe of data we can provide that you can then sort through. And I think it's a bit disingenuous to say that they are looking for the information identified in the Chapin report when that hadn't been issued at the time that these requests were made. That was something that came along later. And granted, that report did identify some shortfalls in DCS's reporting that DCS can now seek to address. And that's something that the legislature and the governor may very well ask them to do. And if that's the case, then DCS will create those public records and ACLU will be entitled to request them. But until that time, they're asking the department to wholesale create a record for them out of disparate data that's located throughout the database. And I would point out that that ACLU didn't complain about the nature or timeliness of the response the department had given until January of 2014, and then immediately promulgated approximately 90 more requests for information. In the interim, in the time that the department hadn't been providing regular responses to their May requests, we'd had the not investigated issue come up. The governor had created the DCS-FS as a standalone agency, and then later special legislative session to create an entirely new agency. There were mandatory state and federal reports that had to be prepared during that time. And during that whole restructuring, the department's information systems team was pretty heavily tasked generating reports for the governor, for the legislature, to try to determine what was necessary to even create this new entity. So, and then on top of all that, they filed a lawsuit. So I think the trial court was correct in saying that, granted, some of these requests didn't get fulfilled for several months after the request was made, but under the circumstances, if you look at the totality of the circumstances, it was reasonable. And I would also like to point out that ACLU has stated numerous times that unreasonable administrative burden is not an appropriate factor to consider in analyzing a public records request or denial of records, but the Hodai case held exactly the opposite, that it may very well be an adequate basis to deny a public records request if it rises to the level of a conflict with the state's best interests. And in here, the state's best interest, if you look at the case they cited, Phoenix Newspapers versus Keegan, the state's best interest is the state as a whole, not the state as in DCS. And DCS has to look at what's in the best interest of Arizona's children. That's its statutory mandate, is protecting children. And if the department has to shut down all of its resources to fulfill 171 public records requests that require detailed analysis, it can't meet its other obligations to Arizona's children. And it's the department's position that that is certainly not in the state's best interest.
We really don't need to address burden, do we, if we decide that, based on a careful review of the record, the database wasn't really in play at the evidentiary hearing, because the court didn't decide the issue. And B, that what is at issue here is the compilation or aggregation of information.
Certainly. There are two parallel arguments, and the court found both in the department's favor. If you have no further questions. Thank you.
Thank you, Ms. Williams. Mr. Beecham?
My client requested these records. You don't request a file cabinet, you request information. And they didn't request the child's database, they requested information that's contained in the database. And the way that information requests are structured, it would clearly call for the right to inspect the child's database if that were feasible. The department did not ever say, until after we filed suit, that burden was an issue. The department in July said, we'll give you the records. In January, we prioritized our request. They ignored it. We sent them a demand letter in April and said, what's going on? They wrote us back and said, we'll get to it someday. They didn't say we're not answering these on burden grounds. The state can't have it both ways. They can't keep records in a way that prevents people from looking at them through some arcane database, and then use burden as an excuse to not let anyone see any records other than the ones they elect to pull out of that database. On cooperation, the suggestion that the ACLU refused to compromise in any way is palpably false. The ACLU on January 24 wrote a letter. It's exhibit, I don't have it handy, but it's an exhibit following up on the May 31 requests. The ACLU wrote a letter before the hearing. They didn't agree to produce the document. Before filing the complaint. They did not agree to produce the documents. On May 14, Exhibit 12, the ACLU sent a prioritization and an offer to cooperate on request, to which it received no response. On May 22nd, the ACLU asked for information about the department's concerns and did not receive any of it until after it prevailed on its motion to compel. And on July 11, 2014, Exhibit 30, the ACLU offered to eliminate 57 of its requests and only proceed on 10 of those requests, only one of which was a Category 2 request. The ACLU, the government had no response whatsoever. The government would not let Mr. Espadas talk to the ACLU, even though he had questions about the request that might have made it easier. And the government did not tell Mr. Espadas about the ACLU's efforts to cooperate. Even in the proposed form of judgment that we filed, which is Appendix 1 for us, I don't remember the IR number, we said the same thing there that we had been saying. Here are the requests we really need. And it adopted the offer to modify and cooperate on the other requests. The ACLU got zero response. The government has done everything it could do to make this as burdensome as possible.
May I ask a question?
Yes.
Before you sit down, Mr. Beecham, in reviewing the record, I noted that the proposed findings of fact and conclusions of law submitted by the ACLU were not in the formal record. What we have is a notice of lodging, and somehow the Clerk of Superior Court separated them out, and so we really don't have them in the record, although we have them as an attachment to your brief. Does the department object to the inclusion of the findings of fact and conclusions of law submitted by the ACLU to the trial court as allowing us to consider them, or do we need to issue an order directing the parties to jointly submit them because they were in fact submitted to the trial court? No. Okay, so.
Mr. Beecham, before you sit down, I asked her a dumb question. I have one for you, too. And I'm trying to accurately paraphrase what Ms. Williams said. But I assume you disagree that this is either correct or dispositive, the assertion that making a document or report from disparate data is not required by the public records law.
I disagree with that. The government agency must either provide the information in raw data or provide the aggregation, one or the other.
That goes back to what I understood by your previous argument was that you can't require quantification or distillation, but you can require aggregation.
That's correct, and I believe that's what our requests do.
I know I'm oversimplifying everything, but I want to make sure I had that clear. Thank you both for your arguments.
And again, I'd like to underscore how much we appreciated the amicus brief in this.
We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.